think because it's so last 17/9 it was
After Diwali.
obviously.
Madam, yesterday's hearing matter, madam.
Ah.
I want to realize some decision.
Please.
The pray for listing of a matter which was
Bail.
no transfer petition. Madam.
State side diba. Bail holo immediate diba. Baki. Yes, bail.
Criminal revision petition, Lordship. The matter was last listed on 10 February to 25.
Immediately after vacation. Where is your mention memo? You have.
Lordship, there is an urgency in the case as well.
Immediately after the.
May I please, Your Lordship? This case has been taken by my ma'am, but the client has taken back the file in 2016-7-1.
Fine, we'll consider. You don't appear, we'll consider.
For listing a criminal revision petition.
What happened to the divorce petition? Settled. Withdrawing. You are for the?
I am for the petition.
You are Mr. B. Islam. Mr. B. Islam, Learned Counsel for the petition, submits that during the pendency of the present proceeding, the matter has been settled between the parties and accordingly prays that he be permitted to withdraw the present criminal revision petition. Prayer allowed. Criminal petition, revision petition stands dismissed on withdrawal. Interim order passed earlier. Analyze interim to payment as well.
Lordship, I am appearing in item number 8, my lord. The appellant has expired, my lord. He is no more.
Mrs. J.M. Learned Counsel for the petition submits that during the pendency of the proceeding, the appellant herein had passed on, on
That thing,
as passed on a few years back.
2 months back.
Few months back. Full stop. Accordingly, she submits that the present petition appeal stands abated and the same may be closed. Full stop. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the criminal appeal stands closed on being abated.
An appeal 388 of 2013.
3/8/2023, huh?
2013.
30. Yes, ma'am.
Duly obliged.
4 to 9. Today may not be the appropriate day to take it up because we'll not have time. We'll have it immediately on reopening. You can give it.
W's who has deposed.
You can give it. As prayed for by the Learned Counsel for the parties registered to list this matter on. I'll just keep it and then we'll take it up on 24,
Yes.
on 24/10/2025. 24 to
24th October.
4 to 9, 8 to 8 is
24/10.
close.
Ardhu-
You are also prepared, but today if I take up, I'll not be able to touch the other matters.
24/10.
24/10. Any problem?
Obliged.
Okay. On that day, we'll close it, ma'am. Only certain queries I have. Madam, I have some queries. I'll just ask that. Give me a clarification. I'll close it on that. Yeah.
May I kindly pass over the matter for the time being?
Today, time is very precious today. No, today itself. Yes, what did you find? Who is appearing? Okay, okay, Rutaman item. Today may be an auspicious day for Nargis, madam. Tell her. Tomorrow, I don't know where I'll go. It's a case with regard to forgery of genuineness of a note. But what I find is that the requirement is that knowingly that money was being used. That is not being established. That part is not established. So let's see how they go about it. Yes, where is Mr. Sharma? Hmm. Madam, what do you think about this case? But see, the factor, just think the situation there. He is said to have cut the ropes. That is normal in the villages. You close the doors with rope. No, there's no point in that. But along with the victim girl, her sister was also sleeping. So the rape cannot be the consent because that girl was there. So he coming into the, and she also says they were having a love affair for around 2 years. So lurking house trespass may not be.
That is another aspect.
Then with regard to rape, 376. Hmm. Hmm.
What circumstances he has given?
See, the circumstances here is said that to be the proposal for marriage. But it is not established that the factum that the petitioner, the accused from the day one was only making that promise by mouth, not by heart. That is not established. And see the factum, he comes into the room, accesses the room very freely. And the victim, because her leg touched the sister,
Sisters, huh?
so she shouted, the incident came out. Otherwise, the incident would not have come out.
Earlier occasion also he has.
He has committed, and that is basically now the things have come out. But she was a consenting party.
But under what it is a mistaken of fact that will come under section 90 IPC law.
But mistaken of fact,
Her statement is also
pregnant also 12 weeks, whether the pregnancy is of the boy or something else,
that has
very
to be looked
difficult.
into.
Very difficult. Because if the sister had not made that sound, this incident would not have come out.
Otherwise,
And he was also at one point of time agreeable to marry her. Some member he has approached. Mahila Samiti also came in.
yes.
They are not there. None appears for the petitioner on call. Ms. Bora Lanan, additional public prosecutor, is present for the ends of justice registry to list this matter again on 23/10/2025 for further hearing. I found a matter today. It's there in the list. Therein, while dealing with 376, the trial court came to a conclusion that this was, we cannot say that this is on a mistaken fact that the girl had consented. And the 376, he was absolved. But for on the same ground, 417, he was convicted. So if it is mistaken fact for 376, how can it be for 417?
Thing is that
We'll see. I'll hear you, but I think you will have to be a bit more aggressive in this matter.
May it please your lordship.
Yes, I told you, you do the matter on that day. You did not do.
But I did.
That day I had a doubt.
The
Today I don't have any doubt.
the other side took time.
Whoever,
But here, the exam.
entrustment is proved.
But one thing is not proved, that the question paper, I have done something.
No, that was the aspect which I was having a doubt on that day. How did you deal with the question paper? There is categorical evidence on record of PW 10, who said that you had not, it was a venture school, you had not conducted the examination.
That is,
You were directed to return the papers.
and I have returned to the police.
No, it was recovered from you by the police.
My lord, but ultimately,
Recovered, and
My
you
lord,
deny that.
I-
And you deny that.
My lord-
That you said your case was that no, these papers were not recovered from me.
My lord,
But
only-
you have not questioned the Caesar list. You have not
My lord,
assayed
one
the-
thing, my lord, one thing has to be looked into, that is that, my lord, my lord, in para 2021 18 SCC page 70, para 46, some misdeed has to be shown to be done by.
Misdeed? I'll show you. There is evidence on record
Lord,
when you
because my
returned, there was one.
Allegation was that I have not conducted the examination. Correct, my lord. But after
No.
the examination is over, the question papers were recovered. What misdeed I have done?
One question paper less in maths paper.
My lord, in which evidence I have not?
Yes, it is there. The police itself,
Then, my lord, that evidence your lordship has to give me a time to look into. That evidence, if there is a one question paper less, then I have to think it in another way around. But the judgment says, my lord, the police seized the question paper which were given to the accused during the, along with one notice.
no, accused, police seized, you have questioned the Caesar, but you have not proceeded further in that line. So the Caesar, the memo was given to you. You have not assailed that. You have not disputed that. The memo was given to you.
But as your lordship has said, that one question paper was less. That I
It is
didn't
there.
find, that is, I didn't find in the judgment, my lord,
Yes, it's there.
in the appellate judgment.
Mhm. There was an allegation of leakage also.
No, my lord, that was not the charge, my lord.
Forget it. It's a
My
circumstance.
lord, in page 25, the accused himself appeared
You
before-
come to page 12.
11
PW tens,
and 11.
tens. 1, 2, 3, 4, fifth line and later.
page 12, my lord.
Page 12, internal page 3, 1, 2, 3, 4, fifth line.
Suppose that by him at the examining the question paper of class 9 got leaked out and he got this information from the headmaster. But
And later.
thereafter a meeting was held by the inspector.
No, where are you reading? You
Headmaster-
read internal page 3 of the
My
trial
lord,
court
page-
judgment.
Page 3.
Ah.
Corroborating the testimony of PW 10.
No. Top. First paragraph. 1, 2, 3. The top part. 1, 2, 3, 4. Fourth line. Then they reported the
They
matter.
reported the matter. to the
So,
inspector,
and later
police
police seized
seized
the
the
question
question of the
paper and was given
which
to
were
the accused.
given to the accused.
It was also disclosed by so and so. There should have been 17 numbers of maths question, but
But
one question paper was less.
This aspect, my lord, I overlooked. I will go through it, my lord. That if that be so, then the question comes.
Then nothing is here.
My lord, I will look into
This
that.
is
aspect.
a
The
settled
last time,
position.
my lord, they took time for, my lord. I never took time last time.
And the whole school was closed down. There was no students. That is the evidence. But you still went and brought the answer scripts, question papers.
But the examination was not held. That
But not held by you for some other reason. 406 ingredients are fulfilled.
then, if the question paper, that aspect, my lord, only one chance, I will go through the evidence of that and I will clarify that. Because that evidence I have to look into.
And Mr.
Because,
P.K. Roy Chaudhary is
because
saying
this-
that I can't say no.
my lord, that,
But today,
my lord, because in the appellate, I have gone through the appellate judgment. In that appellate judgment, nothing.
need not be. This is there. Unfortunately, it came to my eyes. What to do?
Not unfortunately, well, I got some education from that. So, my lord, at least, my lord, opportunity I will go through.
PW 10's evidence you see. Mr. P.K. Roy Chaudhary, learned counsel for the petition after arguing the matter at some length, has submitted that he be given an opportunity to make further submissions in the matter on perusal of the trial court records. Full stop. Prayer accepted. Registry to list this matter again on 23. Taste take 23/10/2025 for further hearing. Mr. M.P. Goswami, Learned Edition
Yeah, my
Public.
lord, I will
Prosecutor.
apply for the certified copy of the PW.
We will not. You see here. Morning, the file comes here by 9:30. You can ask your junior to peruse it. I ensure that the files are here.
My lord,
for
I will
them.
go through it. PW 10 I will.
What happened to the title suit, Mr. Burmia? Title suit,
Title suit is still continuing, my
where? Where?
at Silchar,
At the trial court itself,
trial court is.
or it has come up on appeal?
No, no, not yet, man. The suit is pending yet.
Pending.
And the
Who is in possession of the land?
possession of the land ourselves, my lord. We're in possession of that. He is having already the boundary dispute in between. She is having her part, my lord. We are having her. She raised a question that we have encroached that, but
On
Already
the point
over-
of the, we'll uphold the order of the trial court, of the magistrate. The district judge went a bit far away, far ahead,
yes, my lord. The magistrate ordered it as space 40, my lord.
but we have seen that. We'll uphold that. We'll set aside the order, say that it will be subject to the outcome of the trial.
Civil.
Civil. Allowed.
Much obliged, my lord.
Yes, what is the instruction? Yes, Mr. Sharma, anything? Mr. B. Sharma, learned additional public prosecutor submits that he be granted further 10 days time to complete his instructions in terms of the query raised by this court-wide order dated 19/9/2025. Registry to list this matter was denopished date 1/11. We'll see.
Obliged.
Mr. Sharma, kindly get that. 1/11.
Kindly, my lord.
Give me a date convenient to you.
11, my
3/11. Good.
3. Obliged.
Yes, Mr. Ahmed. How can we help you?
Yes, I have gone through the
Ah.
report. But your lordship, 2013 since.
Huh? Maybe
but,
we'll
2
put
years
an end to,
position,
we'll put
it
an
may
end
be-
to that.
It may be some reduce
Reduce, you tell me how much. I'll put that much.
3 months.
Huh?
3 months. Full man now, he's 13 years.
How much? How much? How old is he now?
He's now, when file he has 42 years, when he
Ah.
filed it,
42 years.
50,
He's enjoyed
50,
the protection
55.
of this court.
50.
55, nothing.
He's a one daughter.
elder to me.
Unmarried daughter.
He's elder to me.
And unmarried daughter.
Unmarried
3
daughter
months,
will-
my lord.
Yes, Mr.
Did my lord permission, my lord punishment.
This is a
Cannot-
revision.
Cannot. The revision, man.
I am not going to any argument. So it is reduced.
Yeah, it's no purpose.
6 months. 6 months. I'll put it in your name. Mr. J. Ahmed, learned counsel for the petition, after attempting to argue the matter at some length, submits that the petitioner, in the meantime, has is suffering from various ailments, and accordingly prays that the court would be pleased to reduce the sentencing of the petitioner. Reduce the sentencing of the petitioner as awarded by the learned trial court. Also, Mr. MP Goswami, learned additional public prosecutor, disputes the above submission of the petition and submits that the learned trial court as well as the appellate court, having upheld the conviction of the appellant here, petitioner hearing, this no leniency is called for to be shown to the petitioner in the matter. First, I have considered the submissions of the learned counsel part of the parties and also perused the judgments of the learned trial court as well as the learned appellate court. Also, this court on perusal of the judgment finds that the learned courts below had learned trial court as well as the appellate court had held the petitioner guilty of the charge under section 381 IPC on a strict on a due consideration of the evidences coming on record, and no infirmity therein is found by this court. Also, accordingly, the conviction of the appellant under section 381 IPC is upheld. However, considering the long lapse of time with effect from the date of commission of the offense and the fact that the appellant was litigating in the matter, this court is of the considered view that ends of justice would be met if the sentencing of imprisonment of the petitioner is modified from 2 years as awarded by judgment dated 25/11/2010 by the learned trial court to that of an imprisonment for 6 months. Also, accordingly, the present criminal revision petition stands. Accordingly, this court modifies the sentencing of the petitioner by the learned trial court to that of a sentencing of imprisonment of the petitioner herein by the learned trial court to that of 6 months from the date of rigorous imprisonment of 6 months. For this court having not interfered with the sentencing of payment of fine of rupees 5,000 in default to undergo 6 months of rigorous imprisonment, the petitioner would now deposit the said amount before the trial court. Full stop. In view of the above, the conviction of the petitioner is habil. However, the sentence of the petitioner, he is sentenced to undergo rigorous imprisonment for 6 months. Full stop. Along with payment of fine of rupees 5,000 in default to undergo further imprisonment for 6 months, further simple imprisonment for 6 months under section 381 IPC. For petitioner to appear before the learned trial court, that is the court of the subdivisional judicial magistrate. Mr. Goswami, subdivisional judicial magistrate, he'll appear
Does it?
before the subdivisional judicial magistrate bracketed M North Salmara within a period of 30 days from today, and to undergo this sentence as imposed herein above, as well as for payment of the fine. With the above observations and directions, the present criminal revision petition stands disposed of.
If he,
The
That will
period
be-
of detention undergone by the petitioner here earlier shall be set off from the sentence of imprisonment as directed by this court by the present order.
My lord.
We'll get the order by 22nd only.
May I please the lordship, ma'am? If he has been sent. There is also alternative, the fine is also there. The allegation is throwing brick minor from behind. Madam. So I've gone to the evidence. Madam.
What was the motive?
Told him nothing is explained, madam.
He felt like he wanted to hit, so he.
No, I denied, madam, I denied. Nobody has identified, in fact. In fact, nobody has identified. Only some people. Well done, be my lord.
There is evidence that you can't say that there is no evidence. There is evidence.
If we go by the evidence, no evidence, but PW3, the informant, he said it has been identified PW1. But PW1 is cross-examined, he said he did not see anything. That is the thing, man. Now, since it's a criminal case, probability
Will not
apply, man.
Will not apply.
Whether it be on
Okay, make your submission. If there is nothing, we'll see.
otherwise, my lord, alternative, my lord, the file is there, my lord. That is also there, my lord. 32, my lord. My lord, imprisonment as a description for a term which may extend to, yes, or with fine, or with. That is also there, my lord. One thing, my lord, I like to point out. W3 is the informant, my lord. He is the. There has been some motive, my lord. Nothing has come out, my lord. My kindly see.
There is direct evidence.
Direct evidence, my lord, only, my lord, nobody has seen, my lord, cross-examination, I have read, my lord, this morning, my lord. My lord, he said PW1 supported this case. PW1 cross-examination, first line. I cannot say who threw the piece of brick to the informant. First line. This is the crux of this. Informant, he also said, my lord, he did not see who threw it, my lord. So if we go by the evidence, my lord, maybe, my lord, maybe, and other PWs, all the witnesses, my lord, they say we did not see anything, my lord. Who has threw it? Only thing, my lord, since the people held on one person, my lord, and it is believed that he has threw it. He threw the stone, my lord. that day. And he denied his 330.
But PW1 recognizes the accused.
My lord, kindly see the cross-examination of the PW1, my lord. That is interesting, my lord. He has-
That's the only evidence.
Yes, sir. He has identified in the court, obviously.
No, no,
He-
no.
he has-
He has recognized the boy,
Yes, yes, kindly see the cross-examination, my lord.
PW1.
Only one line. I cannot say who threw the piece of brick on the informant, my lord. This is the full stop, my lord. This is the
Yes, I
full
missed out. Sorry.
stop.
Yes, Mr. Goswami.
1, 3, my lord,
One is the only identifying eyewitness, but
and he
others have not seen it.
but here, my lord, at that point of time, the public gets hold of him.
Nothing has come out that why I will throw, my lord. There is no personal element, nothing is there.
The public, my lord, there is no occasion to catch a person who has not done this. And immediately, and your lordship will shown, he was apprehended, immediately FIR, my lord. There cannot be any check, man.
Found to be superficial in nature. Yes, yes.
We are acquitting him. The cross, he says, in the chief, he says that he saw the young boy throwing. But in the cross, when he was examined, he said that no, when the incident took place, he was inside the PSI or PSI office, and he heard a cry, which he identified to be of that of the informant. Then he rushed out. So if that be so, there is a doubt.
And that is why I am saying, my lord, it is
Public-
regarding the circumstances. If we catch him, my lord, again, he was given. So there-
But
amount of
definitely
evidence,
is
my
not
lord.
there. Allowed.
Come.
I missed out on that statement.
Yes.
Problem.
Please, your lordship.
Hmm.
14, your lord-
Thank you for reminding us that we have matters from 2014 only. So we are not taking it further for a one more day also. Okay. Yes, what do you have to say?
This appeal arises out of 4/9/2013.
Hmm. Hmm.
The accused has been years and
How long were you behind bars before this?
DA case.
Hmm. There was
the
nothing.
defendant never,
After this also you were not arrested. Okay. Yes, what is the error?
the error in the judgment. Prosecution relied upon in the charge sheet.
Your name?
My name is Utpal. Hearing on behalf of. So in the charge sheet,
Mr. A. Chomua might be very busy. Oh, he's always out of station. Huh? Okay. Tell him I told this. Tell him I told this.
basic crux in AD lies upon the statements made by the investigating agency a check period from 1/1/1995, 2nd of February 2002. And I joined in the service on 23rd October 1967. Initially as
19 October,
23rd October 1967.
Hmm.
Initially as sub overseer grade 9 on
then you were
temporary
promoted, you became a assistant engineer. is it?
assistant engineer.
Yes, then
During this check period, they have calculated
okay, let us cut it short. The just on 31/12/2024, when it was seen, before the start of the check period, you had 2 lakhs odd,
yes.
right? After the period was over, it was around 24 lakhs or something. How do you, they have given the details, how do you adjust? it?
Yes, there is the fault. The statement A, statement B, that is the assets and assets acquired during the period,
Hmm.
and the entire
Hmm.
C series and D. These statements are wrong. As I would like to mention one item from statement A, if your lordship has the charge sheet, and statement A, assets at the beginning of the check period.
Charge sheet, you want me to go to the charge sheet?
Charge sheet on last part, after the completion of the charge sheet, they annex
Check
the
period.
statement
Annex
A,
the statement A or statement B?
statement A.
Okay.
The lordship will find in the serial item number B2,
Hmm.
credit balance at account number 2416 UBI, Duliajan branch. That is mentioned as 90,957.23.
Hmm.
Then if we go to the same account, during the check period, it is in the part 2 of third page, statement B,
Hmm.
column number 2. Credit balance in account number 2461 of UBI Duliajan, same account, it is 1,80,123.57. So this statement reflects that I had 90,000 balance prior to check period, and I had account balance is 1,86,000. So this has to be deducted because it is the same account. Prior to the check period, there was 90,000. And during the check period, since it is showing the total amount, so 90,000 has to be deducted.
So in 7 years, around 90,000 was deposited, accumulated.
Accumulated. This is one of the major wrong. That has to be deducted, Your Lordship. Thereafter, if we go into the next page,
No, okay, fine. Okay, fine, no problem. We'll deduct whatever is required. But these are, a statement B is the assets you have created.
assets.
You have created in 7 years
Yes,
during the
yes.
check period.
Yes.
Now, does it, after deducting whatever you had at statement A, commensurate to your income?
So these calculations are also wrong. Whatever is shown in the
No, we are on appeal now. We'll do the calculation. Now you tell me.
yes, I'm coming to that point. UBI reinvestment certificates.
Hmm.
This shows amounts, various amounts. The first amount is 30,800 and something, 42,000, 42,000, 37,000. These are all reinvested amounts.
Where is your evidence to that effect?
PW.
Where is your
Yes,
evidence?
PW 26, 27 and 35.
PW
26.
twenty-six.
26. Your Honor.
Hmm.
26 is regarding bank, regarding the bank deposit. 27 may be the
Okay, do one thing. You
I
give
am
me
coming.
a list, make out a chart that why this disproportionate thing should not be accepted. Make a slip. So we'll have
I'll submit one written argument.
not a written argument. I want the
Calculation.
mathematics.
How
My
is the
maths is
calculation?
very bad. I want the calculation.
I am.
Yes, madam. What is your case?
With the X,
Within 10 plus minus 10% of the
10%.
now it is
It is
around
50.
54%.
4%.
But one thing, what he's trying to project is he had 90,000.
Prior to the
No,
time
no,
period.
no. Then he accumulated 90,000 in 7 years. So it is 1,80,000. Have you taken it as 1,80,000 or 90? He has a point there. That point is there.
Carry forward that 90,000 has to.
So the income within the check period only you can take into account, right? If that is disproportionate plus minus 10
Plus
of the
minus 10 will be-
income, fine. DA case
But only
is proved.
90,000 we have.
How did you do it? Please make your homework. Come back.
My
When?
last subject. Your Honor.
Uh-huh.
The other investments, these are all reinvestment certificates.
Okay, fine. But you show me from the evidence that this was
Yes.
established. You can't put that here. Okay? When?
Then if it is a reinvest, just accumulate. There should be a statement. In the return, we have to give the.
Madam, that would not be if that unit he has purchased prior to the check period. So that cannot be taken into account as an income within the check period. Why I'm telling you? Because that is not a fresh investment from an income made during that period. So those things cannot be taken. So you plus minus that and show me. If you bring it within 10%, we'll let you go. Madam, you also examine that. As agreed to by the Learned Council for the parties, a registry to list this matter again on 27/10/2025. Fine, ma'am. Any problem on 27? Yes, who is appearing for the state?
Lots.
Item number gimana itu? Oh, last one matter baik boleh. Mr. Goswami. Appeal. I can't take it. There seems to be a love affair, but the petitioner, the appellant herein thereafter retracted. And there is an extrajudicial confession also. This is that Mohila committee,
Yes, ma'am.
huh? Meeting and all. None appears for the petition on call. Mr. MP Goswami, learned additional public prosecutor is present. So as the present appeal is pending since the year 2024, this court requested. Who will take it up? Youngsters? Anyone? Amicus curiae, who wants to be? Oh. Sad affair. Hey, Kavak, whom to appeal? Who? Come. Why you can't come on your own? Huh? Or you want a prodding? Huh? How long have you been in practice?
4 years.
4 years, and still you require a prodding. Huh? You are attached in the chamber of Miss Nargis. Oh, you are afraid. Requested Mr. A. Chaudhary to act as an amicus curiae for the appellant in the matter, to which he has agreed. The courtmaster shall furnish a copy of the appeal memo along with his enclosures to Mr. A. Chaudhary. Registry to list this matter again on 27/10/2025, reflecting the name of Mr. A. Chaudhary as amicus curiae for the appellant in the matter. She'll give you a copy on 22nd. File to Akiri. This is the case I was telling you. Para 39. Have you seen it? So if that be so, how can it be taken that there was a misconception of fact for 470?
Slightly different.
Huh?
It's slightly different.
No, here, this case,
It's the same proposition.
the earlier one, there is something. But here, clear-cut finding of the tribunal that for 376, misconception of fact cannot be accepted. So if that be so, how can it be accepted for 417? But still, that misconception of fact should be there. She was convinced that he will marry her. For 376, that is not there. Then how can you have it for 417? It was a consensual relation. None is there for the appellant, we'll appoint somebody and then take it. None appears for the appellant on call. Same order, huh? Yes, who is coming? Who will appear? Yes, come. You will. What is your name?
SKM Alamgir.
SK?
Alamgir.
SKAM Alamgir. Huh? Tar naam to likhi diba? Di diba hai? Copy, bas sake. 28. Huh? When you want it? 25th. Item number 12, 25th. Koi diya. Any problem with dates, just tell me.
Respondent here. My lord,
None appears for the petition on call. Mr. G. Alam, learned counsel for the respondent, submits that during the pendency of the present proceedings, the matrimonial dispute between the petitioner and the respondent has been resolved, and they're living together.
no, my lord. Not. There have been mutual divorces.
Resolved, and the marriage has been divorced mutually. Which has been order dated?
White order dated 26/9/2016.
26/9/2016. 9/2016.
Passed in TSM.
Passed by the learned trial court in title suit bracketed M number 19/2016. Also, a copy of the said order has also been placed on record. Also, in view of the above position,
My lord, some payment has to be,
uh,
the second paragraph, lordship may kindly see, my lord. 1 lakh has been paid and 1 lakh after withdrawal, my lord, in the next page, my lord.
also, the learned district judge, while the order dated 29/6/2016 had recorded the following submission of the learned counsel for the parties. Also, A to A to A, my dear. Also, as the present revision petition is being disposed of today, the parties to comply with the undertaking made before the learned trial court and reflected in the order dated 26/9/2016 within a period of 1 month from today. With the above observations and direction, the present revision petition stands disposed of.
For this
Ms. Bora appears upor likhibade, heard Mr. G. Alam likhijana. Arpishor also heard, yeah. Additional public prosecutor appearing for this day.
Rajman.
My lord, in this 25 1 year, one.
Will you pay the fine? I'll. This is under section
25, my lord.
Oh, okay, we'll give you probation, but you pay the fine. Disposed of. None has appeared for the respondents.
The last occasion also.
Yes,
Purely
date is here.
civil suit. On payment of business transaction.
It's a civil dispute,
Civil
basically.
dispute.
None had appeared in this proceeding from beginning.
After some time, 2-3 days they have appeared thereafter.
Oh, Mr. S. Agarwal is appearing.
Yes.
Can you inform him? We just want to be sure. Huh? Heard Mr.
B.K. Chopra.
V.K. Chopra, learned counsel for the petitioner. None appears for the respondent. Mr. Chopra undertakes to inform the learned counsel appearing for the respondents in the matter about the next date of listing of the same. Also, registered to list this matter again on 29/10/2025. Okay.
29/10.
Yeah.
That's okay. Interim order may be continued.
Huh? Interim order, if any, to continue. But interim order passed earlier to continue until further orders. Yes.
Hello, is it please for 217 for Paris? Yeah, fine of rupees in default, simple individual for 3 months. Higher court has said it same, but just in appeal, it's the punishment in default of fine 6 months to 3 months. PW1 has herself confusing
Hmm?
regarding, they allege that she has become pregnant. Really failed to establish the culprit.
What are you doing? The girl has been married? No.
Actually,
Don't
it
know.
was 10 years.
You don't know about your child also. Hmm?
Actually, both the informant and the accuser neighbors next door.
So you can do anything.
No, actually, somebody has done something.
Now, who is that somebody? That somebody is you only.
Ranjit Kutum. Delegation goes there.
Only the default payment was modified.
Yes. 3 months from 6 months. The benefit of section 3.
Yes. Incident of 2007. Here, that aspect is not there. Which is there? But the Ranjit Kutum was only a suggestion. There was no material brought on record.
Yes. But actually, what happened?
Okay, what happened, we'll come to know now. Babri, what is your 313? What is your clarification?
He is innocent. Actually, kindly cross-examination of PW1.
Okay.
He became pregnant. But from the period of gestation,
Oh, those things are not very material.
actually, what are the next door?
People forget these are just rustic villages, and she is already burdened with a child. How do you expect her to remember everything with clockwork precision? That would have given a doubt. Now the rawness there is very attractive because it shows the bona fide.
Most of the victim informant, there's a selling of county liquor. Well, people have come.
No, where is that material? Show me. Have you gone through the records? We'll have to. Okay. HUD Part 11, counsel for the parties at length. HUD 11, counsel for the parties. Hearing remains inconclusive. Registry to list this matter again on 27, 28, 29, 29, 311. 311. Nothing is there in 313. And what is the cross you wanted to show me? PW1.
Yes. First part.
There were two court witnesses also.
No,
Court witnesses were there, CW. 4 court witnesses. Okay, where is that? What is that you want to show me? Cross?
of PW one at page 50. The accused home and my home is next to each other. Solora is my neighbor in front, and Vidyadhar Dole, my uncle, is another neighbor. Ranjit Kutum, actually it is Kulim, is neighbor of my uncle. Vidyadhar Dole. It is not a fact that I had relationship with love and that I had been keeping a physical relation with Ranjit Kutum. We have cultivate of paddy and we all cultivate. I have 2 elder brothers. It is not a fact that sell Kantilika at our place. It is not a
Okay,
fact that
okay. Madam, you go through it once. 311. Mr. Sharma, when did we fix it? No, Mr. Sharma's case, that you had some problem. Mister, you were not here, I fixed the matter because we'll have to rise early today. On 2511. 2511, no, 2510. Any problem on 2510?
I'll be out, my lord.
When do you want it? After 25, any day. Madam would not be.
November.
First week of 311 করে দিব item number A to Z change করেছিল 12 no problem, that's why, because there is some arguable thing you wanted you to argue and we can't leave that opportunity to hear you. Yes.
Where the petitioner and he was months and a fine of 5,000 with simple imprisonment 1 month and a fine of 20,000 was respondent number. They had a live-in relationship. Subsequent.
Okay. Let him go through the brief. It's my fault today. Our briefs came a bit late. You go to.
Just in 1 hour, my lord.
Okay, fine. As agreed to by the Learned Council for the parties, the registry to list this matter again on 8:30. See. 111. Think something is there. Love affair gone sour.
Concern.
Hitting may not be.
Yet expect I'll.
You're having interim protection. Continue. On the next date, we will examine if we can acute you. Acquittal may not be proper. Maybe we can give you a probation.
Induced.
Too much to say that with this evidence. Let's see. That's why I want him to go through it. Yeah.
7.
Yes, Mr. Chaudhary. Mr. Hazarikan.
66A. 7 years.
Is it that case, Shahari?
Yes, madam. I want to point that here, madam, the evidence have been already totally overlooked by the Learned Court factor below minor. Vital evidences, madam.
Yes, Mr. Goswami.
My lord, last
Okay.
cases I have-
Okay. Okay.
Look,